shut down and the health emergency was declared, or the pandemic was declared in March, we really knew as a global community that COVID had arrived in January. So, and by the time we get to the end of the first 2-month stay, which we'll be talking about shortly, we will be fully 1 year into the pandemic. So yeah, it seems like a good time to reflect a little bit and to figure out what comes next. So can we have the first slide? So this is just a short overview about what's been happening over the past year. COVID arrived as a global health phenomenon in January. It was declared a pandemic in early March, and shortly after that, there was a state of emergency declared in the United States nationally and in New York State. The New York State of emergency was declared on March 7th, and 13 days later was when the official statewide moratorium was declared by Governor Cuomo by executive order. A week before that, some of you may remember that are New York City residents, things had stopped in New York City a little before that. So March 16th was the last day of in-person regular court, pre-pandemic normal court. And March 17th was the first day of emergency operations. And then that following Monday, the 20th, was when the statewide moratorium officially began. So for those first 3 months, everything was on pause. We talked about this in a previous training, but the court continued to operate for emergencies, which were defined to include post-eviction presentations. So people who had been evicted who were seeking to be restored, those cases moved forward. Illegal lockouts moved forward. Emergency repair cases and harassment cases were allowed to move forward. But normal repair cases, the ones which were not declared, which were not considered to be absolute emergencies, and most eviction cases did not move forward during that time. Then, and evictions were on hold during that time. So March 13th was the last day in the city that people were evicted until late November of 2020. And after June 20th, and actually before June 20th, there were a series of court orders which restricted how the court would be operating. After June 20th, landlords were permitted to start filing cases again. So eviction cases could be started. And some of the cases that had been filed previously started to move forward through the court system. However, one thing that the court put into place during this time is that they were operating as much as possible through remote proceedings. And so the volume of cases that the court was able to process was much lower, and cases were proceeding at a much slower pace. Then in October, and before October 1st, I think was the official day, that it was possible, there was because the moratorium had expired and no new moratorium had been adopted, it was hypothetically possible for evictions to begin after October 1st. However, the court put together a series of protections that would basically require landlords and tenants to be evaluated before they would be permitted to be evicted. And so there was a process, there was a special part called a HMP part, housing motion part, where there would have to be court review and approval before an eviction could take place. And if it was approved, there would have to be reservice of a marshal's notice of eviction. So if there was a prior warrant, eviction was hypothetically possible. If there was not yet a warrant, the landlord could seek that warrant. But again, there was a limit on how many cases could be heard because of the restrictions on in-person operations in the court. And there's an enormous backlog of cases that weren't able to be processed. So a lot of things were happening during this time. One thing that's been happening is that tenants who are facing eviction are, there's a high priority that's being given to trying to assign those any unrepresented tenants to council. And that's been an ongoing process since the court has been operating. And in November and December, there were some evictions that happened in the city. So I think I counted, and I think I counted 7 residential evictions in the city in late November and December. So a very small number compared to what had happened in the past, but there were some evictions, and there was nothing to stop more evictions from happening. Well, not nothing, but there was no moratorium in place aside from a federal moratorium, which the CDC put into place that people could claim by submitting a hardship form. So let's go on to the next slide, please. So there's been a change. And so what happened at the end of 2020 is that New York State on Christmas Eve, the legislature passed an actual eviction moratorium. So remember, the first moratorium was not by legislative action; it was by the governor's executive order. And then there were subsequent executive orders as well, and also by court orders and court administrative orders in terms of how court would operate. So finally, we have an eviction moratorium that was passed by the state legislature. That was December 24th. Governor Cuomo signed it on December 28th. And what it does is it provides for basically a 4-month period in which there is a potential moratorium for New York State tenants. In the first 2 months, which runs out at the end of February, almost all cases for eviction are paused, are stayed. The court cannot move those cases forward. They can't hold a conference. They can't sign a stipulation. They can't. The cases are basically on hold. The exception for those cases are cases in which, and it's defined in the statute, so it has to meet the precise language in the statute, but basically nuisance type cases, meaning a tenant is alleged to be committing acts that are substantially interfering with other tenants or with the landlord, such that there's like an immediate ongoing threat and the definition of nuisance is that it's chronic and persistent and it can't be, quote, cured. And so if cases are in that category, they can potentially move forward, but all other eviction cases are on pause for the first 2 months until the end of February. There is no restriction on tenant-initiated cases, so repair cases, HPs, harassments, illegal lockout cases, those cases can all move forward. So that's what's happening for January and February. And then after, I see a question in the chat about what a hardship is. We're going to spend a lot of time today talking about that. So please let us know if we don't answer your question when we get to that point in the presentation. So after the 2-month stay, which protects everyone, except for those tenants who are accused of committing nuisance type behavior, cases can hypothetically proceed in court unless the tenant submits what's called a hardship declaration form. So you may remember that I mentioned there was a CDC form. That was a federal declaration form that some tenants may have submitted. This is different from that. This is a state form. And we're going to show an example of it in a few minutes, and we're going to walk everyone through the criteria for that. But basically, if a tenant is covered by that hardship declaration, which has multiple parts to it, they sign the form, they can submit it to their landlord and to the court or to either one of them. And if they do that, that will stop any eviction action until after May 1st. And so a lot of what we're all doing now is assessing with people that we're working with and advising people that we aren't working with yet. They have the opportunity to submit that form if it applies to them, and that will give them a protection from eviction until after May 1st. So that applies to not being able to bring a case, not being able to proceed with a case, and not being able to move forward with an eviction. So that's going to be the next 2-month period after the first 2-month moratorium expires. Can we have the next slide? Okay, actually, we're going to pause at that point, right? And open it up to questions. I'm just going to caution you because we are going to go into the details of the hardship form. But if people have any questions about how court is operating, and we'll save time for questions at the end as well. Anything that was covered by the beginning part, please feel free to ask those questions now.
I don't have any hands raised at this time.
Okay. So I'm going to pass it over to my colleague, Carissa, to talk about some of the details of the hardship form. Carissa, you're muted. Oh, sorry, you need a minute. No problem. I can, okay. Here we go. So people have a lot of questions about these forms. So we tried to break this down as simply as we can. It's a lot of slides, but hopefully we'll be able to answer a lot of questions that you may have.
Yes. Yeah, sorry about that. I was there's a lot of things going on my screen. We're going to go over now where tenants can submit the completed hardship declaration forms and what exactly constitutes a hardship, to answer that question that came up in the chat. So there's a couple places that tenants can actually submit a hardship form. Wait, let me make sure I'm not too far. Okay, first question actually is, how will tenants get a hardship declaration form? So there's a couple ways, again, that people will get it. The first is if you actually have an active housing court case with the courts, then the courts are trying to mail everyone who they think has an open and active case this declaration form. I know a couple of my tenants who have active cases have already received forms. This includes cases that were started before 2020 that might still be open. And we say might because in some of those cases, the courts may not have gotten their requisite documents to know for sure that they're actually closed and that the tenant has fulfilled the stipulation, if there was a stipulation in that case. So even if you had an old court case and you're not sure that that case was closed, like you might be receiving it in the mail from the court. You can also get the document from your landlord. And if the landlord provides this form, then they have to provide an email address or an address where the tenant can actually submit the form. You can also get the form on the court website, and the link is here. Which I should mention now that these resources, this material will be available to participants of this workshop afterwards, so you'll get access to this link. The form will be available in 8 languages, and the legislation stipulates that if it's being mailed or given to tenants either through the courts or through their landlord, that they must provide it in the tenant's primary language. And I think there's something they're supposed to do if the tenant's language isn't the 8 primary languages, but I'll let Beth say something about that. Am I right?
Yeah, you're right. So the court is obligated to translate it into the language which they've already translated into. And additional languages as practicable. So they've determined that it's only practicable to do those 8 languages. So the statute actually requires the landlord to translate it into the tenant's primary language if they're providing it to the tenant, if the court does not offer that translation. That's what the statute requires.
Okay. So if you get the form and you fill it out, there's a couple ways that you can submit that form. You can either submit it directly to your landlord. We do not recommend that you submit it in person to your landlord because you want to keep some sort of record that this document was actually given to your landlord, because then your landlord is required to make sure that that's sent in to the courts. So keep any copies and receipts. If you're going to, the best way to send it is through some sort of certified mail. And we recommend that you keep any copies or receipts to verify that you did submit this document. You can also submit it to the housing court. So you can submit it by mailing it into the housing court, or each local housing court will have a drop box outside of the court where you can drop it off in person. You can submit it to the housing court via email, and we've included the email address here for the Bronx Housing Court, where they'll be collecting the declaration form. A part of the materials that'll be available afterwards will include the email addresses for the other borough housing courts. You can also submit it online through NYSIF. And that's if you have an active housing court and you know that housing court case, and you know that your case has been converted electronically. And so this is the website that you would submit that document to. And the last way that you can submit it is through the Housing Justice for All website. They are making it really easy for tenants to submit this form online, and they'll have you put in your information, your landlord's information, and the information of your local housing court, and they will send those documents to all parties. And this is a great way actually to send your form, because Housing Justice for All, it is another great resource for tenants in general. It's a coalition of housing organizations, tenants associations across the state that have actually fought for some of these protections that we've won. So they are trying to submit as many of these forms as possible, because there is a deadline to submit this form. I think it's February 29th. No? Beth, you look, okay.
No, I don't think there's a deadline. I think there's a hope that anyone who wants the benefit of the protection will exercise that option. But actually what they told us in a court meeting was that even if you submit it later, it'll stop things in their tracks at that point in time, whatever the point is that you submit it.
Okay. So this is what the form looks like. And again, it will be available in different languages. So it should be this 3-page document. And it will outline the different reasons why you qualify for hardship protection, or how you qualify for hardship. So what does qualify?
I'm sorry, Krista, can we go back to that form just for 1 second? I just want to highlight, if I could. This is a writable PDF, and it's also available on the court's website. It's important, if you have an index number, to write the index number at the top of that page and the court. And then you also have to indicate which of the sections apply to you, sign, print the name, and date it. We're going to go through, Chris is about to go through all the instructions about it, but I just want to mention that you should definitely indicate your index number if you have it. I know we said, and we'll be getting to questions later, that you can submit it to the court and to the landlord. Even if you don't have an index number, you can still sign this and submit it to the court. And the court is keeping a list of all those tenants, so that if a case is later filed, they can hopefully match up the declaration form to a case, even if it hasn't been filed yet. Thank you. So there are two things, two kind of broad categories that you have to meet to qualify, or conditions that you have to meet to qualify as experiencing a hardship and qualifying for this hardship, this protection that this form gives you. So the first is an experience of financial hardship. And then the second is a health, that you would experience a health risk or have a health risk if you were required to move. So according to the state of financial hardship, there's multiple, I guess, conditions that you can meet that would qualify as a financial hardship. And they're all listed there on the form. So the first is, if you have to meet one or multiple of those conditions, or at least one of them. So the first is if you have experienced a significant loss of household income during the COVID-19 pandemic. The second is if you've had an increase in your necessary out-of-pocket expenses that are related to performing a job or related to health impacts during the COVID-19 pandemic. The third is childcare responsibilities or responsibilities to care for elderly, disabled, or sick family member during this time, and it's negatively affected your ability
or the ability of someone in your household to obtain meaningful employment or earn income or increased your out-of-pocket expenses. If moving expenses and or create a difficulty for you in securing alternative housing, and that makes it a hardship for you to relocate to another residence during this time, that would be considered a financial hardship. And then last is other circumstances that are related to COVID-19 pandemic negatively impacting your ability to obtain meaningful employment or earn income or have significantly reduced your household income or significantly increased expenses. And this is kind of a catch-all to indicate that if there's an extent to which your household income or the increased expenses have not been offset by any public assistance or any public assistance, which would include unemployment, pandemic unemployment, disability, paid family leave that you've received since the start of the pandemic, that would, qualify you as experiencing a hardship. And this is that language in full. And so the second is that if you had to vacate the premises of your current apartment to move into new permanent housing, that would actually pose a significant health risk on either you or one or more members of your household because they have an increased risk for severe illness or death from COVID because of age, disability, or an underlying medical condition. This would also qualify you as experiencing a hardship and in need of this protection from eviction. So you have to qualify under one or both of A or B. And I think we're going to stop there to take any questions about the hardship form itself and what qualifies as hardship.
So we had Miss Lisa Diagasis. His hand was raised. I'm going to allow her to ask her question now. Miss Lisa, can you unmute yourself, please?
Hello.
Yes, we can hear you.
Hi. My question is not about the hardship of this form, right? But it was something that was said before about illegal lockup eviction. Before you started saying the examples of what a hardship form is and what you could do with it, I have a question, right? Does illegal lockup evictions include having your daughter removed from your home? Like if she lived here, but you don't want her to live here and you don't want to let her in, is that the same thing as an illegal lockup eviction?
I can try to answer that. And we can also ask if you have a specific question. If we don't address the full question, you're more than welcome to reach out to us after the training and we can hopefully try to follow up with you to give you more specifics.
Okay.
But so I think what you're describing is what we would call a roommate holdover. So in some cases, somebody may have somebody living with them that they wish to remove. Those cases cannot proceed right now. You can't evict people right now. Even if it's, in my understanding, even if it's a roommate. And if somebody did lock somebody out, that person would have the right to seek the court's assistance to get back in as an illegal lockout.
Would I be fined or arrested?
I'm going to ask you not to ask more about that. I'm sorry
Okay.
to
I
ask.
wanted to ask you, can I come into your office to ask these questions?
Yeah, so
So-
let me talk right now about how we're operating, and maybe that'll help answer. So we are operating largely remotely like most providers. However, we are so what we do is we ask people to call our main number, which is 718-220-4892 extension 101. We are doing a limited in-person intake, and we do that on Friday mornings between 8:30 a.m. and 11. So if someone's not able to access us by phone or they have technical challenges, we are doing a limited in-person intake on Fridays between 8:30 and 11 at POTS.
Extension 101?
Yes, ma'am.
Okay, thank you.
Okay, good luck. Thank you. Thank you for your question.
Okay.
We have Miss Yvette Soto asking, are the hardship declaration forms, can undocumented individuals apply using the hardship declaration form?
Yeah, absolutely. There is no restriction on anybody's immigration status in terms of availing themselves of the protection. Thank you for the question.
And Ms. Cruz is asking if there will be a link to the presentation slides, which we will be emailing in a couple of days, I believe.
Yes. Yeah, we'll send a PDF version of the slides. And if we can't make the notes in the slide available, we'll send the actual slides themselves available to make them available so you can see the notes.
Okay. Thank you, Carissa. Maeve is asking, is there a consideration of hardship for those with non-physical disabilities?
So the health issues come up in two different ways. One is the subsection B, which is pretty specific in terms of how it defines who's at risk of illness or death. It's a little bit vague, but it's also, some of it is very specific. So the other section that potentially applies is earlier in, I think it's subsection A4, where it speaks about if you were forced to secure other housing, that would create a financial hardship because you don't have the means to secure that other housing. So I think health can come up in a couple different ways here. And I think the legislature was trying to cover a range of options, the way they drafted the way they wrote the legislation. So if somebody, for example, had a mental health condition and didn't lose any income and didn't have any increased expenses, but having to relocate would be financially would create a financial hardship for them, then they could be protected under subsection A.
Thank you, Beth. At this time, there are no other hands raised.
I think I saw a question also in the chat about languages, which languages it's being translated into. So according to the court, the ones that are available on the court are English, Spanish, Arabic, Bengali, two versions of Chinese. They call it simplified and traditional. I'm not sure if that means Mandarin or exactly what that means, but they have two versions for Chinese language, Haitian Creole, Polish, and Russian.
We have a question from Ms. Stephanie Orange saying, do I need to send a doctor's letter to my landlord along with the form stating that I am at increased risk of severe complications from COVID-19 and
So
cannot work at this time?
that's a great question. So I want to answer it this way. The CDC form also provided for potential eviction moratorium or eviction protection for people if they qualified under the language of that document. What I heard is that some people who submitted the CDC form got questioned about it and felt they had to prove, or were asked in court to prove, that they actually qualified for the protection there. There's nothing in here that says you have to prove this. The way this is written is if you claim the hardship, everything stops. If you submit the form and sign it and submit it, everything stops. Now, that said, it should be truthful. If you're signing it, you should make sure that it does apply to you and that it's truthful. But you do not have to justify it. You do not have to prove it. You just have to, you can claim the benefit of the protection. That's the way it's written.
Thank you, Beth. Ms. Shanetta Gaydon is asking, what is the current status of eviction? Um,
Okay. So the current evictions are, except for the nuisance type holdover cases that might get court approval, evictions are completely on hold for the first 2 months of the year. So until the end of February. The other thing, which is a technical thing under the statute, is, but this will probably make sense to some of you. The warrants that were issued in the past are not good right now. And so if a landlord had a warrant before, they actually have to get another warrant issued if they want to evict somebody before May 1st that has specific language required by the statute. So that is going to cause a delay as well. So right now nobody is supposed to be evicted until after the end of February, unless the court approves it in a nuisance type case and unless a proper warrant is obtained. After that, if the tenant claims the protection of the moratorium through May 1st by submitting the declaration form, again, unless it's a nuisance case, those cases are also, or those evictions are also on pause until May 1st. So there's going to be we hope that there will be very few potential evictions because of those protections. And remember, I think someone else just put a question or comment in the chat as well. Remember, there is still court oversight of evictions. So this is adding additional restrictions to restrictions that were already in place. And so the basic rule of thumb is that there has to be court review before anyone could be evicted. And that we hope is going to protect people from eviction. But we're going to say this at the end, but it doesn't hurt to say it again. Anyone who's at risk of eviction should be trying to get legal assistance at this time. There are legal services available. There are offices that are working with tenants that are available. And we would hope that no one is trying to negotiate all these challenges on their own, because there's a lot of protections that are there. And to be able to get the benefit of all those protections, we definitely recommend that everyone get counsel if at all possible.
Thank you, Beth. We have a question from Ms. Melba Cruz asking, wouldn't they need to still file a new motion?
Right. So I think that's related to that's the question I had seen. So every case is different. A lot of things would have to happen for someone to be authorized to be evicted right now after starting March 1st. So I'm just going to, as I said before, the previous protection was that if somebody had a judgment and a warrant, and the landlord had to get permission to move forward to make sure that the tenant wasn't covered by what's called the Tenant Safe Harbor Act, which we're going to be speaking about a little bit more in a moment. The Tenant Safe Harbor Act provides that in a non-payment case, if the tenant had a financial hardship and was unable to pay the rent from March 7th, continuing through the time that there's a restriction on public gatherings I think it's in the county of residence, then that tenant is not supposed to be evicted for the rent that they're unable to pay during that period of financial hardship. So that's that's a lot of words. But yes, that protection still continues. And so there has to be court review in any non-payment case where a landlord is seeking a tenant's eviction. The tenant has the right to say, I had a financial hardship. I couldn't pay my rent because of the financial hardship. It's been during the period of public emergency, and therefore I cannot be evicted. And then the judge, the way that law is written is that there could be what's called a money judgment, meaning the debt would be owed to the landlord, but the tenant would not be able to be evicted for not being able to pay that rent. So there does have to be court oversight of those evictions. Yes.
Thank you, Beth. Miss Evelyn Shannon is asking a question. She has her hand raised. I'm going to ask that she unmute herself. Ms. Shannon?
Hello, can you hear me?
Yes, we can hear you.
Okay, my question is, I don't have a court paper, but we received letters. We live in a private house, and we received letters. All of the tenants stating that as of February 28th, he doesn't wish to renew any of our tenancies. There isn't any court paper, but just the paper that was a letter that was served to all of us. So, in terms of eviction, how does that work for us?
So the answer, most questions that we get, we always say the answer is it depends. And the reason is that there's particular facts that may apply to you that would give different protections. But basically, if you're in a private house and your lease is expired and the landlord's saying they don't want to continue it, the landlord, if you don't leave, you could choose to leave if you wish, if you're able to. The landlord's letting you know that they would like you to leave. If you're not able to or you don't choose to, the landlord would have to start what's called a holdover proceeding, giving you notice that your tenancy had ended and they wish for you to vacate. But they have to go through an eviction process, and there's certain notices that are required depending on how long you've been living there and what type of tenancy you have. So I definitely would recommend that you, and most people, if they've been, I believe you've been there at least 3 years, you would get at least a 90-day notice before that case could even be started. So it would make sense to connect with an attorney when you get that notice, but you shouldn't be at immediate risk, even if you are unable to leave by that time.
So the letter that was given to us was in December. Is that considered from December to February a 90-day notice?
No, I can't answer. I don't believe, from what you're describing, it doesn't appear to be a notice, but you would want to talk with an attorney to make sure you understand what notices are being given and what notices you're still entitled to.
Okay, because I know that he's trying to sell the house, so he wants everybody out.
This can happen where that's what they want. That doesn't mean they're entitled to it and within the time that they want it.
Okay. All right.
Okay.
So in terms of a hardship for moving, because we're trying to get the monies together to move, does that apply to us in terms of a hardship or filling out paperwork?
Let me think for a second. So the hardship has to do, I'm just taking a step back. The hardship is targeted more for, it's not limited to non-payment cases, but it's more about, do you have a financial hardship? So if you would have a situation where it's not easy for you, you would have a challenge moving because you don't have the finances to vacate, then that section 1, under section A, that should apply to you. But I definitely encourage, it's hard to answer general questions. It's hard to give general advice to specific presentations. And so I would encourage you to get some individual advice, and you're more than welcome to contact us if you want some more guidance on that.
Thank you, Ms. Shannon.
So I know there's maybe one more question, but we're gonna ask to hold it for the end so that we can just finish the presentation and give others a chance to ask questions based on the rest of the presentation. So let me reshare my screen.
Okay. So, so I think we all have a lot of questions about what happens after May 1st. What's going to happen? How soon is it going to happen? And again, the answer is we don't completely know. One thing we want to make sure to remind people of is that the COVID rent relief program has reopened. So remember, that's the state program administered by HCR that provides that if a tenant had a financial hardship and was unable to, actually, no, it doesn't require them not to have paid the rent. If the tenant had a financial hardship between let me back up. If the tenant lost income during the period that's covered by the rent from April through July of 2020, they can apply for rental assistance from the state to cover all or a portion of their rent for that period. Many people applied for this in the past. Very few people were approved. there was pressure on HCR. They didn't spend all the money that was allocated. They spent less than 40% of the money that was allocated, and they reopened that program. And the new deadline for that is February 1st. So anyone who has not already applied for the rent relief program should definitely apply before February 1st. And we have a link to that program there. If you applied before and you were not approved, they've said that all those applications will be reconsidered. So it is possible to still be approved under the prior application. And the hope is that there will be some additional rental protection that's provided, that's available to tenants in New York. We don't know yet, but that is the hope. So I would encourage everyone to follow the media, and certainly we'll be happy to share any updates that we receive about programs that are available. But right now, the only rental assistance that's been offered, aside from getting specific assistance, is that rent relief program, which is only for rents that were due between April and July of 2020. You know, we've also heard on the news talk about a possible additional federal protection, more rental assistance. We know New York State got additional money from the federal government. So again, we hope there's gonna be additional funds that are available. In the meantime, there are many groups out there, including HRA and the home-based providers and a lot of charities, including POTS, that are available to work with tenants one-on-one to try to create a plan for how to access assistance if people are unable to cover the rent and they're at risk of eviction. So the bottom line to this question is we don't know. We're hopeful that protections will continue and that additional protections will come together for people, but there is a huge, tremendous amount of need. And we are really hoping that there's going to be additional assistance that's available. Can we have the next slide? Okay. And then this is just a reminder to make sure to stress again that the Tenant Safe Harbor Act is still in place. So the Tenant Safe Harbor Act is was passed by the state legislature, and it provides that if a tenant had a financial hardship for the period covered by the state emergency, which started March 7th, and they owe rent after that period, they may not, the landlord is not supposed to be able to evict that tenant if they're unable to pay rent due to a financial hardship. So what happens in those cases is the tenant can assert a defense. When you go to answer the case or where you call to answer the case, you would say that you had a financial hardship, and it would mean that the court would have to evaluate whether you're entitled to eviction protection. And so if the financial hardship is established, then the rent would still be owed to the landlord. So the landlord could potentially get a money judgment, but they cannot get what's called a possessory judgment, meaning they cannot evict for the rent that came due during that time. And that protection continues as long as there's a restriction on public gatherings in the county of residence of the tenant. So as long as those restrictions happened, as long as those restrictions remain in place, that's a continuing protection. I see a question about can the money affect your credit? Yes, a money judgment has credit consequences, and it is much better if tenants can access rental assistance and not have that debt at all. But it is still a significant protection that they could be protected from eviction if they're not able to pay those arrears. We put this in the presentation because we want to remind everybody that when papers are filed in court, there are additional protections. And so this is an example of an insert that had to be included by landlords when they started cases, letting people know that they have additional time to answer potentially, and also sharing a link to the court webpage. And as we mentioned before, the city has been providing legal services support to tenants at risk of eviction, and this is the main number to contact to access that assistance. We understand that it can be hard to get through, and it can be hard to get an attorney assigned sometimes depending on the volume. They're also prioritizing cases that have the most immediate risk of eviction. So but it is potentially available to anyone meeting their income guidelines, which is below 200% of the poverty line for the family size. And we encourage everyone who does not have counsel to contact that number if there is a case that's active in housing court. And this is just a reminder to please keep your eyes open for those extra papers. Things look different now than they used to, and there's a reason for that because there's potentially additional protections that people have. So please pay attention to those notices and save your papers if you do receive them.
So I'm going to keep my video off because I think my my teeny computer can't handle it, and I'm making it a little slow. But there are a number of resources right now for tenants. As Beth has already mentioned, there are nonprofits and other agencies like POTS who are providing assistance with resolving people's rent arrears, and that are also providing legal services to people who are who have cases that have been started against them in housing court. And we will send a list of those agencies to you guys with the materials for the slideshow. But there's also city agencies like HRA and Homebase, which has the aim of preventing people from getting evicted. So we do recommend that you go to these offices, particularly Homebase, which is a kind of a clearinghouse. They can put you in their system to start a case with you, and they can also give you referrals for other agencies. So that could be a first stop for a lot of people facing eviction or who just need help with paying off the rent arrears that they owe. Housing Court Answers is another really great resource. They have resources on their website for tenants, landlords, and advocates who are working in this field. So we highly recommend going to their website as well to kind of get an idea, a lay of the land for what's out there, for what your rights are. And as their name suggests, you can also go to them to ask questions about housing court. You can also go to HCR, which is Home and Community something.
Renewal.
To get a printout or to request a registration history for your particular unit. And that allows you to see the history of the rent that's been charged for your particular unit, to see how your rent has been increased over time. That's a really good resource for a lot of tenants to turn to. If you are receiving Section 8 right now, Section 8 is operating remotely, and you can always access a lot of their services on their websites. I don't know what's happening if you need to like recertify or anything like that for Section 8. Beth, do you want to say something about that?
Yes, we shared this in a previous training, and basically every agency has online access for recertifications. So if anyone has a specific question, we can try to get you that information. But the Community Service Society has done trainings on this, and I think we shared that in a previous PowerPoint.
Yeah, and POTS Legal Clinic, as Beth mentioned, we are operating. So if you are not already a client of ours, you can get on our intake list by calling this number here, and we'll put you on our list to have an intake with one of us to start receiving support. We want to reiterate again how important it is for people to get legal representation, especially if you've already received documentation indicating that your landlord is taking legal action against you. And that is the number that you can call to be assigned an attorney. So that concludes our presentation. For the next couple minutes, we can take some more questions.
Yes, so Ms. Shannon asked, does Homebase or any of the charities help with relocation expenses?
Well, I can't speak for the individual home-based providers, but my understanding is that yes, either HRA or home base or some of the charities are potentially available to help with relocation expenses. So if someone needs first month's rent, security, brokers, or moving expenses, those things are all potentially something that can be applied for. There are some legal protections. So if somebody, so HRA, for example, will give a security deposit voucher. They won't give a security deposit. So there's some restrictions on what's available. And some landlords or potential landlords don't like those restrictions. But yes, they are hypothetically available. It's just if it's the main challenge that I see with those is sometimes the costs are substantial and they could, and so it would need to be something that's manageable based on the amount of the expense.
Thank you, Beth. Ms. Karen Prince is asking, what about if you do not owe rent, but there are paperworks that you are asked to give to prove your income, but you don't give them those, you don't give the landlord this paperwork mainly because the way things are now. You're not even sure if you're going to keep your job. Can the landlord send you to court?
That's a hard question to answer because again, the answer is it depends on what type of housing you're in. There are some, so in general, I don't think the landlords would be asking you to prove your income. That's not something which is required. However, I have to qualify that there are some types of housing that do require it. So for example, there's some landlords that get a something called a low-income housing tax credit. And in those low-income housing tax credit buildings, there are income certifications are required. And if a tenant does not provide it to a landlord, the landlord can seek that tenant's eviction. So if that's the case for your building, then I would say, yes, you are required to provide it. And people get confused about that sometimes because they may not know if they are or they're not. So my advice would be if if a landlord has asked you to provide that, I would ask them why. And if you want to know if it should apply to you, you should seek legal assistance to find out if you're required to provide it. There are also buildings that are income-based where you might have a subsidy attached to your unit. So if that's the case, then you could be required to provide that information. But in general, it's not required unless some specific program covers you.
Thank you, Beth. It appears you answered Ms. Shannon's question, Ms. Prince's question. Ms. Cynthia Morero is asking, can tenants use helping other family members financially, quote, considered financial hardship?
Yeah, I would look closely at the language of the hardship declaration form and make sure that it applies. So I don't know the answer to that off the top of my head. I would want to look, you know, most people have lost income and or had increased expenses. So if that applies to you, then you wouldn't have to go into this factor. And if it would be a hardship to relocate and that applies to you, then that would be sufficient. That specific quote that's in there, I'm not sure if that qualifies, but I imagine something else might cover a tenant in that situation.
Miss Evelyn Shannon is asking, are you able to apply for Section 8? I don't know.
I'm not sure if that question is whether Section 8 is open right now, or if the question is, can POTS provide assistance to people seeking Section 8? And I will say that I actually don't know if people can get on a list right now to apply for Section 8. There's always huge demand in accessing Section 8 subsidies. I know for the New York City Housing Authority and other agencies, they have huge waiting lists. There are also individual buildings that may have Section 8 that may have applications that are individual to that complex. So I don't know what the current access for Section 8 is in terms of the big big agencies, which is NYCHA, HBD, and HCR. And if the question is, does POTS provide any support for someone who's seeking Section 8? We do have case management services here that can provide some support for some people who are seeking assistance in general, but that's a hard one because you know, if someone has technological challenges where they can't access something, the case managers may be able to help them access something, but they don't have enough resources to do a comprehensive housing search for someone, for example.
Thank you, Beth. And just to clarify, if anybody wants to speak themselves, they could just raise their hands. Ms. Maria Ruiz wants to ask a question, so I'm going to unmute her now, or ask her to unmute herself. Ms. Ruiz? Okay, I
Hi,
guess.
can you hear me?
Yes.
Hi, how are you? I'm calling because going, but it was a lot of difficulty going back.
I'm sorry, we can't hear you now. Are you? I'm sorry, I can't hear. Can anyone else hear? All right, well, I'm sorry, Ms. Ruiz. If you can't get through to ask your question, if you could put it in the chat, or you can also reach out to us for an appointment if you have a specific question.
Okay. Sorry about that, Ms. Ruiz. Ms. Lisa is asking, how can I get a list of landlords that don't allow security vouchers?
I'm sorry, can you ask the question again?
Ms. Lisa asks, how can I get a list of landlords that don't allow security vouchers?
So I'm not sure if I fully understand the question. I'm going to take a little bit of a leap and say, I think what you're asking is which landlords will accept a voucher, that's what you're looking for. And what I will say is it's HRA's position is that it's illegal for landlords to decline those vouchers. And that's supported, that interpretation is supported by the New York City Commission on Human Rights. So if a landlord says they won't accept a security deposit voucher, that we recommend that people file a complaint. There's a unit of HRA that takes those complaints, and there's also the City Commission on Human Rights that takes those complaints. And what they do, what those agencies do in that situation is they will reach out to the landlord to tell them that they're violating the law and then they have to accept it. And so we often see that they're able to help people access housing when they bring it to their attention. But we often find that people report a lot of discrimination by landlords and by brokers when they're trying to access housing. And people get frustrated and they move on to something else. And they want to know who is not going to give them a hard time, which is understandable. But if people are not challenged when they're engaging in that discrimination, it's going to continue. And so we recommend that people bring it to the attention of a legal services provider, to the City Commission on Human Rights, or to HRA, so that hopefully they can assist the tenant in getting past that discrimination and accessing housing. So to answer the actual question, I don't have a list. It's illegal, except for very small landlords. It's illegal, and you should speak to a lawyer or to those city agencies about that discrimination. There's another question about which brokers can be used. So I don't have a list. I don't know what that means in terms of which brokers can be used. I don't think there's a limit. How do I answer this? I don't think there's a list of which brokers are acceptable to others, if that's what you're asking. And it's really more a question of what are landlords and brokers asking for as move-in expenses, and is the amount they're asking for legal, and that's something that has to be reviewed either by HRA or by the agencies that if someone is seeking that assistance, financial assistance, that would have to be reviewed on a case-by-case basis. But no, I'm afraid I don't have a list of brokers to reach out to.
And I do not see any further questions, no hands raised.
Okay, well, if that's it for the questions, then that ends our presentation. As we said, we will make the materials for this presentation available for you guys afterwards. We'll send out the PowerPoint as a PDF and as slides. We'll send out a list of those nonprofits, charities, and legal service providers that you can have to refer back to. And then we'll also, we've been recording this session, so we'll also send out a recording of this presentation. So thank you all for joining. We appreciate you guys coming out. Please, give this information to others that you know who are also struggling with their housing right now. So
Thank
enjoy
you
the
all
rest
for
of your
joining
week.
us. Thank you all for joining us. Good luck.